All right, welcome everyone to today's session on the recent High Court case of Hill and Zuda and the impact of this decision for your SMSF clients around death benefit payments. So I'm joined today by Chris. So again, welcome and thanks for joining us. So Chris is the co-founder of Inherit Australia and also works with us. And I think, Chris, you and I have been sort of working on the Smarter SMSF deed since 2016, 2017, I reckon, maybe earlier.
So we're both here on that.
Yeah. So, this decision is pretty impactful from the context that we have a High Court decision that gives us, application around the way in which binding death benefit nominations obviously apply in the context of SMSF. So this is something that has been, we've been seeing at a state level for some time in different jurisdictions, but this High Court decision really now cements the views that we have seen within the industry for some time. So as is always the way with any of these sessions, you need to understand the context in which we are presenting this to you today. So in terms of what we're going to cover, we'll spend a little bit of time helping you understand the facts of the case and therefore the decision that was finalised in Hill and Zuda. And then what we want to do is kind of move on from that and work through what we see are a number of practical implications that will be impacting your SMSF clients. And there'll be some slides we'll talk to, and Chris and I will have a bit of a general Q&A, and again, an opportunity for you to be asking some questions around that as well. We'll then move in and have a bit of a discussion more specifically around the Smarter SMSF deed and how we have long held the view, obviously, that is pretty much in line with what this decision is and following what the ATO guidance has been previously through SMSFD 28/3 and then again through case law in various state jurisdictions. And then again, we'll have some time for general Q&A at the end of today's session. So, Chris, I'm going to maybe get you to have a bit of a discussion about the facts of these case, where this, I guess, originally started from, and ultimately where we concluded in the High Court.
Yes, thanks, Aaron. Well, this is all too typically a sort of blended family dispute. Mr. Soddy, as you can see here, had a de facto spouse, Miss Murray, who were members of the Holy Super Fund, and they were directors of the corporate trustee. And Mr. Soddy had a child from a previous relationship, Claire Hill. She wasn't biologically connected to Miss Murray, so it was a stepchild to Miss Murray. And what's quite unique about this case is that Mr. Soddy created a death benefit nomination, but he had it inserted into the deed by way of a deed of variation that was made in 2011. So he created what was effectively a binding death benefit nomination that was written into the deed. And there's been a lot of discussion about SMSF wills, and we'll come back to that topic a little bit later, but this is one of the features of this particular dispute. It wasn't a separate document, it was actually hardwired into the deed. And what he said there was quite simple, which was that if either he or his partner died, the first of them to pass away, their death benefits would be paid to the survivor. As simple as that. So obviously, the daughter missed out under this regime from the death benefits. And of course, Mr. Soddy, as is usually the case, passed away, and the daughter then challenged this death benefit nomination or this form of nomination, and she commenced proceedings in the WA, Western Australia Supreme Court.
And I guess this is where things have carried on, haven't they? Because they've started in the Supreme Court, and then thereafter we've seen it go to appeal. But the context in which this argument was being challenged was consistent, I guess, all the way through ultimately.
Yes, and look, I think one of the I don't want to draw on the politics of this, but this was a WA court, making a decision on effectively whether Regulation 617A applied. Now, up until then, we had two cases, but they were Queensland cases, Munro and Munro, and then Donovan, which was implicitly cited in the High Court case here, that had said that Reg 617A didn't apply because Section 59A of the Act did not apply. So, but Ms. Hill argued here that she said, well, look, if you read Reg 16A, it refers to the operating standards, and the operating standards under Section 31 applies to all funds. So therefore, 617A must apply to all funds. And so that was, in simple terms, the gist of her argument, that it should apply, and therefore the fact that this death benefit nomination was written into the fund was an invalid nomination.
Yeah, and the decision therefore was unanimous. I guess that the decision of the High Court was quite clear that 617A simply doesn't apply to SMSFs.
Yeah, and what the court took was rather a nuanced view of its reading of Reg 617A and said, yes, well, maybe the operating standards apply to all the funds, but the Reg 617A4, which talks about the form of nomination that we're all familiar with, the 3-year binding death benefit nomination, that did not apply to an SMSF because it was specifically carved out under Section 59 of the Act. There was a circular sort of reasoning approach, and so that's been, and so this issue has laid to rest the issue of whether 617A applies in other states and not in the Queensland jurisdiction, which made it really clear in Munro that it didn't. So we now have this High Court decision that applies across all jurisdictions.
Yeah, and I think if I'm correct, Chris, the High Court also referred to the Cantor management case as well in South Australia as in a similar guise. So we now have ultimately the highest court of Australia. And I think I had a discussion on the podcast recently I did with Bryce at DVA Lawyers about, it's the vibe. The vibe is quite clear now, isn't it, with the High Court, that 617A does not apply to an SMSF.
Yeah, and if you read the judgment, it's one of the shortest High Court judgments I've ever read. So it was an unequivocal thump of the gallop that it doesn't, that 617 doesn't apply to SMSFs, and that's sort of now echoed, obviously, the ATO's view, as you've mentioned, and of course the Queensland cases that we've mentioned.
Yes, and so that determination, you can see at the bottom of the screen there, SMSFD 28/3. So it's, I guess, a non-binding nomination. A determination on the commissioner, but in essence, that's kind of what we have followed suit with for some period of time, in particular since the introduction of the BDBN measures, sort of around that point. So. So let's kind of move on, because like I said, there wasn't a need to move away from the decisions that we'd seen in the previous court. So I think that's the most important thing. So if it was grossly wrong, then the High Court may have considered otherwise, but those decisions in Naruman and Munro and all those really confirmed the way in which those jurisdictions applied the rules were applied correctly. So this is, I guess, Chris, where I'm really interested to kind of help line this back up for our listeners today around the practical implications here. So can I get you to just elaborate on some of this a little bit further?
Yeah, thanks, Aaron. So what it really means is that we sort of now come back to what was the status quo and the fairly commonly held view that your SMSF can prescribe the form of nomination that is required for our death benefit to be made binding. That is, because it doesn't have to follow the Reg 617A template nomination, which is a lapsing 3-year nomination, we can now have a non-lapsing binding nomination, which the deed will create, and it allows funds now to be bespoke in the way they approach that process.
Yep. But we have this issue where and you would see this probably as much as I do, potentially even more, but the fact that whilst the regulation doesn't apply, quite often we're seeing the importation of that regulation into the deed, which then all roads lead back to having to comply with what those regulations require the fund to do so.
Yeah, and so what's ironic about this case is that everyone's concerned about whether Reg 617 applies and therefore throws out all of the deeds that have said otherwise. But surreptitiously, most deeds that we see, and I think what you see, implicitly bring in those requirements. And I'm not sure if that's because of the uncertainty about whether 617A applies and therefore the flight to safety, so to speak, with the draftsmen of the deeds to say, well, look, let's make sure it's in there. But the reality is that most SMSF deeds out there follow that approach by importing Reg 617A.
Yeah.
And
maybe the Donovan case here is the interesting one, because Chris, this is where you go to and look at the deed, and the form of nomination, as it says here, said it needed to follow the statutory requirements. And when you look at the the definitions around this, as you can see on the screen here, what the statutory requirements actually set out, it means the requirements that were imposed under any law or by any statutory authority, which must be satisfied by a fund in order to qualify for the concessions. And it sort of goes on from there. So it's interesting that when the court's view was then that in the judgment is quite plain and clear that the intent of the deed is to require the nomination to actually follow the form described. So again, we're going back to the deed and the rules of the fund to look at how the nomination should apply. But because we've got this importation of the requirements in 617A, then we go back, we're kind of in this vicious loop, aren't we, whereby the fund actually needs to comply when quite clearly, the view is that we don't.
And of course, added to that or compounded to that is the fact that some of the deeds, and this is probably a little more, we'll see something in a moment with Munro, but this deed was a little bit more prescriptive, and some deeds are very vague about whether Reg 617A applies. If my memory serves me with Donovan, I think he wrote his death benefit nomination on a bit of paper. And the question was whether that piece of paper, that was a direction to the trustee as to how his death benefits were to be applied and whether it was binding on the trustee. And so in that case, it says the court found that it wasn't, because the court said that based on this particular drafting, and every deed is different, but based on this particular drafting, this clause imported all of the requirements and all the features of Reg 617A. And because that wasn't followed, it wasn't signed off by two independent witnesses, it wasn't a binding nomination, and therefore the existing nomination failed.
Yeah. And this goes into things like the acceptance requirements by the trustee to ensure validity. And again, I think that was one of the issues in the Cantor management case around the serving of the notice. And in that instance, I think fortunately in the end it stood up because the corporate trustee in Cantor was the registered office of the accountant, so it could be argued there. But quite clearly, again, we're going back to what does the requirements of the deed require us to do. And the flag, I guess, for you as advisors is to say, if it is looping you back into the regulations, then you should be looking at this further, because it's not what is required under the superannuation laws. And I guess, Chris, you were just about to talk to Munro there, so I might get you to explain this a little bit further, because obviously the decision did refer to this case as well.
Yeah, and Munro is a case that the court went the other way, which is really highlighting the question of what does the deed say and how do you interpret the deed about this particular issue on Reg 617A. In this particular deed, it referred to what was described here as the relevant requirements, which the trustee must comply with to avoid a contravention to qualify. And what the court said in this case, as opposed to Donovan's case, and these are both Queensland Supreme Court decisions, was that it distinguished Donovan and said, well, it didn't import Reg 1617A because it wasn't prescriptive in its nature. It just had to do something that avoided a non-contravention. And so it said that that wasn't enough for Reg 617A to apply. It was more focused on the fund maintaining its qualifying concessional tax treatment. So again, this is another case where a different drafting in the deed gives you a different result. And therefore, it's really important to understand the deed that you're dealing with.
Yeah, so I think that's very much the lesson in itself, is be aware of the deed and understand the requirements that it sets out, whether it be in the context of importing, as we spoke about, the requirements of acceptance, whatever the case may be, that clarity around that. And if you are unsure, then go back and have the discussion and be asking about it in the context of this current Hill versus Zuda decision. So, Chris, I'm interested now, I guess, having a bit of a discussion about some topics. And this is an area that you obviously do a lot of work in around SMSF wills and the prescriptive nature of the way in which death benefits and so forth can be documented into the rules of the fund. So, because what this really confirms is that the way in which an SMSF will can operate absolutely stacks up. So I guess some commentary for you around these particular topics.
Yeah, thanks. I might hasten to add that our previous colleague, Ian Glenister, was the author of the SMSF will concept in Australia, and it's been a feature of your deed for many years. But the topic of SMSF wills has surfaced in the industry, just reading industry comment from other advisors. So I thought we would address it. I think what's unique about Hill and Zuda, which, as we said at the beginning, is that the death benefit nomination was hardwired into the deed as opposed to being in a separate document that was written by the member and handed to the trustee or kept on file. And so this has revived the whole question about an SMSF will, because by its nature, an SMSF will gets hardwired into the deed. At least that's the way your deed works.
Yep.
And so, as I've mentioned, as you can see on the screen there, I think that we will see more SMSF deeds going forward because it provides more certainty, not just because Hill and Zuda involved effectively an SMSF deed, because it was hard, the death benefit nomination was actually in a deed of amendment.
Yep.
But because it will provide certainty around a whole bunch of issues about whether it exists in a separate document, whether it's served on the trustee like we saw in Cantor, whether it followed a prescribed form that was compliant with the deed, or whether it was incorporated. You avoid, if you hardwire something into the deed, you avoid this whole discussion about whether a separate document complies with Reg 617A. Because 617A is talking about a separate death benefit nomination, a piece of paper that is given to the trustee. So put aside the creative features of an SMSF deed and what you can do with it in terms of being prescriptive about how assets are dealt with within the fund that form the death benefit. We will see, I think, more SMSFs wills, or that's my prediction, because it makes it simpler to just simply hardwire it into the document, and you eliminate a lot of uncertainty.
Yeah, so Chris, the interesting thing here, I guess, to give people some context around this is this is not taking a trust deed and actually doing the edits in the deed itself. The way in which we can effectively import additional rules into the deed is by what we call a special rule of the fund. So can I get you to explain to the audience today, what is a special rule of the fund and how we achieve that through the Smarter SMSF deed?
Yeah, that's a good question. And to put it in context again, Hill and Zuda was actually a deed of amendment.
Yep.
But the SMSF will works effectively like a deed of amendment, except the difference is that it's a special rule. I think it's made under Rule 1.7 of your deed.
Yep.
That is approved, and that means that that rule can only be changed by the member affected. So, but by making that rule a rule of the fund, it is adopted into the governing rules of the fund as if it was written into the rule via a deed of amendment. So the practical effect is exactly the same as if you did it through a Hill and Zuda method, which is do a deed of amendment. Yep. So it achieves the same, but in perhaps a more convenient manner, because those rules can be changed by a special resolution.
Yeah, and we do that special rule of the fund on a broad range of things as well. So it's not only in respect to things like SMSF wills, but it's also in respect to things such as income streams as well, whether it's an income stream ordinarily, or maybe something like a conditional pension too. Yeah.
So but it achieves the same effect as being a rule of the fund, as opposed to being a direction to the trustee, which is what a normal death benefit nomination is.
Yeah, it's a really important point, I guess, for everyone today to understand, because more and more, Chris and I work with some of our members as well, that I guess have some of the specialist skill sets, that we are continually looking at the deed to identify areas that may need to obviously manage incapacity or estate planning or whatever the case may be. And the lever that we have here is the fact that we can do a particular document that sits on the side and allow for that to become a special rule of the fund. And I know, Chris, you and I have been talking in recent times around key decisions to deal with things like incapacity and so forth. And it's these type of things over the journey that allow us to go, well, actually, if we want to insert this in on based upon different scenarios, we will do so by way of creating an additional document, and then that document effectively annexes itself to the deed in its own right.
Yeah. And I think what is also adds value and importance to the concept of a special rule is that if you look at all the history of these cases, Donovan, Cantor, Hill and Zuda,
Naruman,
Naruman, the court applies black letter law. They just look at the terms of the deed and they interpret the deed. They don't use it. They don't use materials to interpret the deed, but they don't exercise a discretion other than what the deed allows. So where the focus is on the deed and the rules of the fund, which is the court's approach, it's certainly, I think, safer to adopt systems and processes that hardwire, where appropriate, rules into the fund, because that's where the court will be focusing its attention.
Yeah, absolutely. So we've actually got a question here, because it goes to this very topic. So I guess, and Chris, you touched on this before. It has this decision resurfaced some of the debate, around, well, which document should we be putting priority over if we think about pension documents and the fact that we may have reversionaries in place, or whether we should be relying upon the binding death benefit nomination, and which one we ultimately want to outrank the other. So, which one should obviously prevail. And in particular, if there's an inconsistency there as well. So I'm interested in your kind of take on that, and I guess what you need to be aware of, because one of the questions we've got here is just to provide some comment on situations like where we have reversionary pensions in play. Yeah,
it's a really good question, and there's been a bit of debate in the last few weeks from different commentators about this whole issue. And I guess the question comes down to, ultimately, as we've been discussing here, about the terms of the deed, and whether a reversionary pension trumps the death benefit nomination. I think the issue for our audience is that it is clear and certain, well, either way you do it. Now, some commentators, and I think Bryce Fickett is one of the advocates, that you should have a binding death benefit nomination that overrules everything, and that's one approach. the view I think that we have is that, and this is just going on the ATO's view expressed in the Law Companion Guide 2017-3, is that a binding death benefit nomination does not of itself make an income stream reversionary. And if the governing rules of the fund don't expressly provide for a pension to be reversionary, the BDBM cannot make that reversionary. And there's this whole focus around the pension being automatically reversionary or automatically being paid on the death without the exercise of a trustee discretion. And I think the ATO's view, and I think the traditional view, is that whether a pension is reversionary or not is usually found in the pension document. And so the issue is, well, what happens if you have a death benefit nomination that says something inconsistent to what the reversionary nomination says? How do we deal with that? I think in your deed, Aaron, it's quite clear that a death benefit nomination only deals with non-reversionary pensions.
Yes.
And otherwise accumulation interests.
Yep.
So there's a clear distinction between a reversionary pension will operate independently of a death benefit nomination.
Yep. With only one exception, I guess, Chris, and this comes back to the concept that we introduced into the deed when the 1 July 2017 changes were around. And this is this concept of a paramount document.
Yes.
Because what it enables, I guess what we wanted to achieve was a solution inside the deed that was agnostic ultimately to the outcome that you'd want to achieve. And the mechanism that we introduced within the deed to allow for that to happen was to say that if you want in the event of a dispute or a conflict between two things, that you can choose or elect to have one document as the paramount document, which then overarches any other document that would exist that would be in conflict with that. So yes, ordinarily, if we have a pension in existence with a reversionary, that auto reversionary would actually naturally carry on in respect to the way in which it was constructed initially, or the fact that you may want to alter the terms and conditions of that pension to make it reversionary. But if you have some other document that is in conflict with that, and if that document, or in the instance with the pension documents, and that is one of the features of our Smarter SMSF deed when you set up a pension, is that you can not only make it a special rule of the fund, you can also make it a paramount document that then says, well, if there is a conflict, we want the reversionary to outrank any other document. Or conversely, around a BDBN or something, then you can elect to do that as well. So I think that's an important part where we say, we don't want to force you down a particular path. There may be reasons why one avenue is better than the other, and it's about understanding the client's circumstances and getting advice around that to ensure that you have a more bespoke approach ultimately to what you can see there of the decisions for that particular individual.
Yeah, I think, and it allows a lot more flexibility in dealing with excess transfer balances.
Yep.
And this is a topic for a whole nother session, I think, but particularly with blended families, you could have a paramount agreement which sits across the top that might say, well, I want part of my pension to be reversionary and part of it non-reversionary, for example. Yep. Maybe that part of the pension that is going to be paid as an excess or in excess of the recipient, spouse or partner's transfer balance cap, maybe that part is to be transferred out as a lump sum to a child from another relationship. You could have a paramount agreement that can pull the strings and to create a more custom outcome when we're dealing with excess transfer balances. And that's where the paramount agreement becomes very useful. And I agree with you. I think the approach here is not to be prescriptive in the way the deed's written, but to give it as much flexibility for advisors who use the deed and for their clients to create very creative estate planning solutions or outcomes.
Yeah, because I mean, if you did put it into a BDBN, it could become something quite complex and detailed in terms of all the machinations. Whereas what ultimately you could have here is a combination of pension documents and a BDBN that may be somewhat prescriptive in terms of how benefits are be dealt with. But the combination of those two things together can achieve an outcome ultimately that we wanted to get in different scenarios. So I guess, again, there's no hard and fast about what's wrong or what's right. But what is important is that you have a set of conditions or levers within the deed that allows you to make these decisions. And part of this, and this is, I guess, Chris, why you've created Inherit Australia as well, is that this is some of the discussion that can be happening at the advisor level, to be starting to frame up these conversations with the clients about these issues, and then bringing in the lawyer to obviously overlay the requirements and in terms of drafting some of those decisions as well.
Yeah.
All right. So I guess, Chris, the other thing here is, you touched on before some of that transfer balance cap issue and so forth, but what are some of the benefits that we sort of can see here to the approach that we've taken?
Yeah, so you can have as I've touched on, you could have, for example, as we know under the current rules, when a person has a death benefit that's in, whether it's reversionary or paid as a pension to a recipient spouse, if the payment of that death benefit or that pension results in an excess transfer balance to the recipient has the choice to sort of roll back to accumulation phase or cash out.
Yep.
Well, what we can do with a paramount agreement is that we can be more prescriptive about what happens. We might say, well, no, my spouse, $1.7 million is enough. She's got maybe $1 million in her own pension account or her own accumulation account. We may only want to revert up to her transfer balance and then pay the excess out to maybe children from another relationship.
Yep.
So as you've got there, the paramount agreement could split assets and make it partly reversionary and part of it non-reversionary, for example.
So that could be by percentage, it could be by dollar amount. All that stuff can ultimately be prescribed.
Yeah, and to get the benefit of the 12-month credit, pension being reversionary. So again, that's just a simple example of a blended family, and we're dealing at Inherit. We deal with a lot of blended families, and we're seeing more and more, particularly in SMSFs. And obviously, Helen Zuda was a classic case that ended up in court. We don't often see current spouse and children from an former relationship or always in a harmonious relationship.
Surprise, surprise. There's an interesting question here. Just thanks for the comments. And if we do notice the current deed within inconsistencies such as with the reversionary pension documentation and the BDBN, I presume as well, would an upgrade of the deed resolve this matter?
That's a good question. It depends on what the existing deed says. I think with respect to all the different commentators in the market out there, what is important is certainty. I think what people want is certainty. And so if your existing deed is silent, for example, and a lot of deeds are about whether a BDBN trumps a reversionary pension or vice versa, then I would upgrade the deed to like the Smarter deed, which is very clear, but allows a lot more creative solutions and bespoke outcomes for clients with different families. Let's put it that way.
And that's that agnostic approach that we take to this to try and, we can't cover every strategy, but we're thinking quite regularly about issues. So I guess Chris, and talking to this sort of topic with these benefits, is that we are thinking about in the way in which we construct the deed and some of the documents to say, well, all right, well, how do we how do we set up nominations or other documents or rules within the fund deed that says, well, we may want to have some flexibility around how a nomination is to be constructed or to be paid, and the fact that we might want some limitation up to a transfer balance cap or to a total super balance or whatever the case may be. So and then I guess is not only thinking about that, but then we're also looking at other issues to then ring fence what I call some of these strategies that we're looking to put in place. I know, Chris, one of the things that we've spent a bit of time on has been the fund member's guardian, and therefore the role that would play around dealing with not only incapacity, but the payment of death benefits as well.
Yeah. And I think that's all about adding flexibility and as well as certainty.
Yeah. And again, we go back to the fact that this paramount agreement or paramount document concept, therefore, is the lever that we have within the deed that gives you the flexibility to say which one do we want to actually have as a priority. So I think from there, obviously with what Chris has said, I'd reiterate around that deed, but something like, if I just use our Smarter SMSF deed, the fact that you could have that pension as a special rule of the fund, and if you didn't have a reversionary in place and you wanted to, you would be able to go through and make that amendment, so add a reversionary beneficiary into the fund without having to actually stop the pension, because in essence we have a set of conditions that have been agreed to between the trustee and the member, and therefore that adjustment would be able to occur. And again, the fact that it is already a special rule of the fund means that nomination would take place. And if you wanted to make it a paramount document in the event of any inconsistencies in the future, again, you could achieve that outcome. So it is all about understanding the levers that you have and the outcomes that you're trying to achieve for your clients as well.
Sorry, just on that last point, I think and it wasn't touched on in the screen, is that a lot of advisors have clients with multiple pensions. And so this is where a paramount agreement can be very useful in driving which pension is to go to which person. And obviously, if you've got infant children with a high taxable amount, you may want a particular pension being paid to them. So the paramount agreement can be very prescriptive where there are multiple pensions. So I just wanted to add that, because a lot of...
And with particular assets to be leaving as well.
Correct. Assets.
So it might be business real property and so forth that would go to specific kids as well. So Chris, the other thing that you just wanted to touch on is, I guess, we've been talking about this throughout today, but statistically, why this is becoming a much bigger issue as well.
Yeah.
And I might just kind of stop the screen here and we can have a bit of a chat about this.
Yeah. If we look, Aaron, if we look at the statistics, this is based on the ATO's statistics for the December quarter.
Yeah.
There was about 602,000 funds in Australia. And we're talking about SMSF market, which is about 25% of the total market, depending on where you measure it. There was about 1,100 members, and there's $876 billion of FUM with an average balance of about close to $800,000. So we have funds at the moment with account balances on average are close to $1.6 million. Now, we've seen in the last 5 years a growth, according to the ATO, of 38% in the SMSF assets alone.
Yep. And
what that tells us is that over the next 5 years, we will see account balances easily exceeding $2 million and easily exceeding the total superannuation total transfer
balance cap. Yep.
Internal transfer balance cap.
Yep.
And so what all this means for advisors is that this is going to lead to a discussion that you're going to have with your client about what happens to the excess. Does it go to their estate? Is it going to be controlled by their will? Is it going to go specifically to an individual beneficiary? And this broadly means that you will have to have an estate planning conversation with clients, which quite frankly was why Inherit Australia was birthed, to help advisors have those conversations, not just in relation to SMSF assets, but their estate planning generally, but to drive those conversations because you know your clients' affairs and you know how their families are structured, you know their assets structures. You've probably participated in helping develop or acquire those assets. And so issues about the transfer balance and issues about should a pension be reversionary to an individual or to the estate or go to the LPR is really an estate planning conversation. And Inherit is there to equip advisors to have that conversation about their superannuation assets and more broadly their other wealth, and how that's, because there is an interplay between how SMSFs are to be paid. If you had a situation like Hill and Zuda, and you had it wasn't referred to in the will, but if Mr. Sodney had a will that said he left everything to his spouse, and if all the super went to his estate, Miss Hill would have challenged his estate, and that would have been a Part 4 claim. And so this is why you need to have your radar open to the client's estate planning when you're dealing with SMSF death benefits or death benefit nominations, in my view.
Yep. And this really brings into the fact that, something like Inherit is the tool to enable those conversations. And then obviously we work quite closely together around the documentation that would be needed to support, changes to the structure of the fund and the rules and other nominations and so forth. So a question we got here, how prescriptive obviously can this be? So, and I think you saw it saying there, how prescriptive can we make some type of nomination? Can you direct the surviving spouse to commute a balance back to accumulation if needed, so that the death benefit pension can be applied to their transfer balance cap?
Well, I can't see any reason why you can't make it a condition of the reversion that they do that, because obviously under the current regime, for the member to avoid exceeding their transfer, they have to roll back. But I can see many circumstances, particularly with blended families, where a client might say, well, she's got 1.7 or 1.6. She doesn't need another 1.6 because she will. If she rolls back 1.6, she'll have, or he will have 3.2. That's not enough. Maybe he or she may, the surviving partner may not have their transfer balance cap. So it may be appropriate in some circumstances to revert up to that individual, but conditional upon them not rolling back.
And that's where it may be, you might use a TSB at the immediate preceding financial year, so that they don't have any, don't try and be too clever by half, where they might roll something back, I've got nothing in my transfer balance cap, so therefore, there's no problem there. So I think, I guess generally, something like an SMSF will and the way in which you can construct this, and this is what Hill and Zuda really confirms, it can be as prescriptive as you like. Because if the deed allows you to do it, you can actually do that. Ultimately, though, how that needs to be constructed and making sure that all the wheels are turning in the right way, because it's not just the super benefits, it's obviously everything else that goes with it, becomes absolutely critical.
Yeah, and for a lot of clients, they want to get the most tax-effective income paid to a spouse, and they may want to increase the amount that gets reverted, and may reduce the amount going to them through their estate to say, well, look, my adult children are not going to get the benefit of a tax-free income stream, so my spouse will, so I'll give them my estate assets. And this is where the interplay between SMSF assets and estate assets become critical. But yes, the point is you can be as prescriptive as you want to, but it's about making the shoe fit the foot, not the foot fit the shoe, which is what these effectively do.
Yeah. All right, well, let's keep moving. I'm conscious of time. So a couple of things. So I guess this is a thing that I put in quite regularly into some of our product sessions and stuff that we run. And I guess, why do people ultimately come back to us as a provider? And I think today, the Hill and Zuda is a really interesting one here, Chris, because it's this concept of what I call breadth of provider versus depth of provider. And one of the things at Smarter SMSF, we work exclusively in SMSFs, and we have sort of 70 odd documents in this space. So what we see, and I think, again, going back to you referencing it earlier as I did, is when you are dealing with providers that are really at what I call level 1 and level 2, they will replicate what the SIS and tax laws talk about. So in the context of today's session, the way in which the binding nomination and the construct of that will be is that it would have been drafted in a way in which the laws would require you, or the relevant requirements as we've spoken about. So you would see in a lot of those deeds this kind of importation of 6.17a when there's actually no requirement to do it. So this is why I think when you're talking with clients and understanding the context of why we do things the way we do it is because of the depth of knowledge. And this is what I call the level 3 and level 4 strategic and extended thinking, because Chris, I might even get you to talk to a little bit about this bottom level here, but it is all about the fact that we are building documents and we regularly add to these documents, and we build them in a way that we are not only understanding how the law applies, but how we can actually take advantage of the law, and then how we can mitigate risk around those based upon the different solutions that may come about too.
Yeah, and I think all of the cases of Zuda and Munro and Donovan tell us is that where there's uncertainty, people end up in, and where there's conflict, people end up in court.
Yeah, absolutely.
And so I think what sits behind this is the assumption that families are unique and they're complex, potentially. I don't see many families that don't have internal strife or conflict. Added to that, or the potential for, exactly. And we're seeing, multiple relationships, same-sex relationships, people with multiple partners, children from multiple relationships. The modern family is complex and it requires a more bespoke solution. And as you've got their strategic focus on how to deal with their needs. And if you don't have that strategic focus, there will be conflict and we will have more litigation. So I guess what sits above all this is certainty. And from Inherit's point of view, having deeper conversations with your clients about how they want their wealth transferred and managed, and understanding the nuances in the family relationships, the dynamics of the family, and where conflict can arise, so that you create a solution that is custom made for that client with the certainty that comes with that approach.
Absolutely. And I think going back to Darren's question you asked before, this is where you have sort of these practical things that get layered over the top of how the laws and the decisions and stuff would apply. So whether it is appropriate to have a guardian come in and play a particular role to ensure that the outcomes that are being prescribed actually fall a particular way. And it may be simple, even more simple things like the way in which bank accounts need to have signatories sign off on things, so that we don't end up in situations where money just disappears. And in particular, I know you and I have spoken a lot about the elder abuse issue, but these are all things that we can play a role in, not only understanding legally, but also practically how people will need to jump more hoops to potentially dip into something that they shouldn't have otherwise.
Yeah, and look, I think the concept, just to come back to the fund guardian, the concept of the fund guardian is about protecting the interests of the member from elder abuse.
Yep.
And critically putting the advisor into the seat with the client to help manage that wealth and to avoid it being abused. And it allows the advisor to participate in the decision making without being a trustee or to have a power of veto. And that's really, really important. And again, it just reflects the aging of the population, the risks of elder abuse, the greed, I suppose, that exists between intergenerations, and how to best protect that wealth.
Yeah. So obviously, in terms of our own deed, we have a broad range of documents that are available. Like we said, Chris here certainly plays an active role in this, right across all of our Smarter SMSF documents. And then, if you need any other sort of legal certainty around particular documents, then quite often Chris and his team are actively involved in that. We are naturally making some updates from the 1st of July not only to the PDS and stuff, but in respect to the guides, we don't necessarily need changes inside the deed to allow for some of the contribution rules that occurred. We've got some information around that through our knowledge base that explains some of that further if you want to find out a little bit more about that. In terms of some of the features, again, I won't spend a lot of time. We have spoken through this today, in particular around the special rules of the fund, the concept of the paramount document. We get a lot of our members kind of try and understand why we may or may not do this, and hopefully today gives you a little bit more information as to why. And I think the other thing here that is worth noting, and we've had a couple of these conversations over the past month or so, is if you are looking to do deed upgrades, and this is a general comment, not just specifically to us, is not only should you be looking to the deed itself, but you should also be looking to the Constitution, because you don't want to end up in an inconsistency in how decision-making would naturally apply. I guess, Chris, have you got any comments that you'd just like to make on that one?
Well, there's a lot of war stories I can mention, but yeah, obviously with corporate trustees, you need to have a review of the provisions of the Constitution and the deed. I think unlike your special purpose Constitution, most advisors adopt an off-the-shelf Constitution that may be in conflict with the terms of the deed as far as decision making.
Yep.
So it's really important to, if you're going to do that, to be mindful of how decisions are made and whether they're inconsistent at the company or Constitution level with the deed terms.
Yep. So I guess some key takeaways. So from my point of view, obviously we now have a High Court decision that provides absolute certainty that, as we said, SIS Regulation 6.17a and 59.1a in the SIS Act don't apply to SMSFs. That is, unless your deed says it actually does. So Chris, I guess making sure advisors spend some time really understanding the fund's deed and the issues around these things, and I think be asking the questions of the impact of these decisions and whether there are any necessary steps that people should be taking.
Yeah, certainly reviewing the deed, and if there's any uncertainty, get advice, because I mean, just as we've shown, the Munro and Donovan cases had two different deeds with slightly different wordings, or maybe radically different wordings. There were two different outcomes.
Yep.
And if you have a nomination that's invalid, then you're going to have a situation like we saw in Wareham and Marcella, where the trustee is going to have to exercise a discretion, and you will not want to be involved in a case of that nature. I was involved in that case, and it's an unfortunate case for anybody who has to exercise a discretion if there's an invalid nomination, and that's what you would have. So at all costs, you want to avoid clients having to exercise a discretion or having a nomination that was purportedly binding to become unbinding. So that's why it's important to read your deed, and if there's any uncertainty, I suppose, upgrade it.
Yeah.
And
understand the chain that's got you there as well. I think that's the other thing. We're seeing more maturity, I guess, in people starting to look at that to go, okay, well, is the chain of documentation actually in order or not? And if it's not, then let's get that fixed, because the potential implications in the future may mean that a court will look at it and go, well, what you've done from deed 3 is irrelevant because the chain has been broken at that point in time.
That's Naruman.
Yeah.
So yeah, I mean, if you do come to the conclusion that maybe this deed is unclear about Regs 617A and you want to upgrade it, you ought to get all of the previous deeds to see that there's no break in that chain, because it could mean that the upgrade could be invalid.
Yeah. And I think the other thing here is just be clear in respect to how you want certain decisions to play out, and then what documents are required, and how you put some priorities around those to ensure that outcome is achieved. And I guess finally, and Chris, you just mentioned this, when in doubt, seek specialist legal advice. And Chris and his team are certainly there to help, both in the context of the legal advice through your legal, but more importantly about the conversations that you can be having with your clients and the role in something like what Inherit Australia can do as well. A couple of final things. So our SMSF days are coming up. Our Melbourne event is in just a few weeks' time. We have over 60, I think, in Melbourne already. So if you want to be a part of these events and you haven't already, we have a coupon code you can see there. We'll obviously send these slides out to you. We'd love for you to join us at one of these events around Australia between the 14th of July to the 3rd of August. We also have a couple of prizes giveaway in our survey. There's a couple of things we just like to find out a little bit more. We use this as an opportunity to get some important feedback from you, not only about these sessions, but how we might construct some of these things into the future. So anyone that completes the survey, you will go into the draw. So A, to either win a ticket to one of our SMSF Days events valued at $500, or B, one of our CPD quarterly subscriptions for our Changing Face of SMSF that we hold in March, June, September, and December every year, valued at $330. So if you want to find out more in respect to our upcoming events or any other things, you can visit our website at smartersmsf.com. To you, Chris, a very special thank you for being a part of today's session. Your insights are always hugely appreciated from my point of view. And I really enjoyed the opportunity to talk not only on these sessions, but we kind of talk a few times a week on a range of things to keep ourselves interested in what's shaping the SMSF sector. So to you, once again, thank you very much.
Thank you, Aaron, and thank you to our guests.
Excellent. Well, I think that is it, folks. So yes, everyone, you will receive a copy of the webinar slides after today's session. I don't think we have any other questions here. Actually, there's one. Just want to clarify an earlier point. Given 617A does not apply to SMSFs and that BDBNs and SMSF wills both act to constrain a trustee and the payment of benefits, is the main advantage of an SMSF will being that they can embed into the deed and reduce the level of documents. Well, I wouldn't say it's going to reduce the level of documents, but in essence, it allows you to prescribe the way in which you want to deal with the distribution of interests and assets. Ultimately, I think one or more beneficiaries.
A very quick example would be business real property. If you've got a client who's got a son or a daughter working in the business and you want them to have that particular asset, you can make an SMSF will that providing it doesn't exceed the member's death benefit, can pass to that individual.
Yeah, absolutely. So yeah, so it's the prescriptive nature of that that enables that to occur. So that looks like it's it, folks. Thank you once again for being a part of today's session. We will get this recording uploaded and on the Smarter SMSF site as well over the next 24 hours. So if you do want to watch again or share with someone else, please feel free to do so. Thanks very much and bye for now.